Let us welcome Phil Journey with a big round of applause.
Thank you, Mark. So many of you have been with me from the beginning when we had Elmer Broadfoot to deal with.
You're here.
And, you know, when we had the Republican Party and we had all those exciting discussions.
That's right.
Now I serve as a judge. I mean, honestly, what I'm doing now is, frankly, the toughest job I've ever had. Serving in the Senate is a lot more fun making policy than applying it to people. The food was much better there, too. Now nobody can buy my lunch. But, you know, I see things, and I've been in the movement for a long time. Now I'm kind of on the outside because of what I do as a judge. I have certain constraints I have to follow. I want to make sure that no one misinterprets anything I say tonight to infer a candidate that perhaps they think I'm endorsing, or a position on perhaps a case that might come before me. Essentially, what I hope to do for you all a little bit tonight is just kind of go through a little bit of the history, kind of look at American public opinion, and perhaps what could be visited upon us after November. What does the Second Amendment say? It says a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Well, I know in its plain meaning, in fact, I'm doing a legislative interpretation seminar for lawyers soon, and the first rule is that you always go to the plain meaning of the words. Now, when you look at the late Justice Scalia's interpretation of that, he was a literalist, and he also tried to add the layer in that you look at it in the usage of the words of the time. Because sometimes a word 200 years ago might mean something a little different than it does today. When we look at Supreme Court cases such as Heller and McDonald, which Justice Scalia wrote the Heller opinion, a 5-4 decision, it basically stood for the proposition that the Second Amendment was an individual right. It simply reflected reality. The Bill of Rights, the first 8 amendments, or the Bill of Rights, did not create a right of the people. It simply recognized it because those rights existed before. And so when you look at European forms of government, for example, their founding documents, their constitutions tend to be a lot longer than ours and not quite as succinct as our Constitution, but they also grant rights to the people, when in fact our documents recognize that those rights are unalienable, is the correct word. Inalienable is the one that we hear used in the common vernacular, and it means that you can't put a lien on them like you can put a lien on property. They're unalienable when you look at the actual wording in there and in the writings of the time. A little different term than what we're used to today. But it means that individuals, when you look at Heller, have the right to have the means to protect themselves and their families, to be subject to reasonable restrictions, you know, that the government, the legislature drafts and writes. For example, felons can't possess firearms legally. Individuals under 21 by federal law cannot purchase a handgun, and cannot, if they're under 18, can't purchase a rifle. Doesn't mean they can't possess it, but they simply can't purchase it. Now, when we look at the history of the interpretation of the Second Amendment, Kansas was the genesis of what is called the collective rights theory. There's a Supreme Court, Kansas State Supreme Court opinion from the last century that essentially said that it was a collective right, that it was the state that possessed the right and not the individual. Because a collective right is kind of like a collective farm. When everybody owns it, nobody does. And so it was the state that had the right to resist the oppression of the federal government, not individuals. And so that pretty much was discredited by Heller and the Supreme Court opinions in that one and McDonald. McDonald stood for the fact that the way Chicago's ordinances were written were unconstitutional because basically there just wasn't any way to get the gun to protect yourself. Now, we also have the issue of the common defense. And I think it's important to put in context what founding fathers, or those closest to the origination of the document, had to say about the right to figure out what they meant when they wrote those words that I described at the beginning of our talk. For example, Charles Beard, an American historian wrote, you need only reflect that one of the best ways to get yourself a reputation as a dangerous citizen these days is to go around repeating the very phrases our founding fathers used in their struggle for independence. Thomas Jefferson, of course we all know, President of the United States, Secretary of State, author of the Declaration of Independence, one of the main authors of the Bill of Rights, and certainly helped drafting many of our founding documents, including he wrote the Virginia Declaration of Rights, which predated the Bill of Rights, said that no free man shall ever be disbarred the use of arms. He also wrote, the strongest reason for the people to retain the right to keep and bear arms is, as a last resort, to protect themselves against tyranny in government. He went on to write, and what country can preserve its liberties if its rulers are not warned from time to time that this people preserve the spirit of resistance? Let them take arms. The tree of liberty must be refreshed from time to time with the blood of patriots and tyrants. In a letter to James Madison, he wrote, the few cases wherein these things, the proposed Bill of Rights, may do evil, cannot be weighed against the multitude, where the want of them will do evil. I hope, therefore, a Bill of Rights will be formed to guard the people against the federal government. And this was correspondence between our founding fathers as they're trying to figure out what to say, what to write in these documents. And I think that is definitely an expression of their intent. Sam Adams, he signed the Declaration of Independence, was organizer of the Sons of Liberty. Anybody see the HBO special? That was really a good mini-series. If you haven't, you ought to go back and find that one. I thought it was great. It's another bearded, bald-headed lawyer out there fighting for freedom. He was of the Boston Tea Party, Continental Congress, governor of Massachusetts. He said, and that the said Constitution be never construed to authorize Congress to infringe the just liberty of the press or the right of the conscience, or to prevent the people of the United States who are peaceable citizens from keeping their own arms, or to subject the people to unreasonable searches and seizures of their persons, papers, or possessions. That very wordage was adopted in the Fourth Amendment. Richard Henry Lee signed the Declaration of Independence, author of the Anti-Federalist Papers. You all know, like when they were having this discussion about what to do, you know, they had the Articles of Incorporation, and it didn't really work very well, and they couldn't figure out how to raise money to fund Congress. After the war, they said, we need a better system. And so, you know, they all got together in Philadelphia and did the Constitutional Convention. And Richard Henry Lee said, when properly formed are in fact the people themselves, and include all men capable of bearing arms. And when you look at the laws of the United States and the state of Kansas, you can look at Title 10, Section 311, and it describes the militia, the unorganized militia, as basically all men, ladies, sorry, you're not included, that was the way they wrote them back then in 1792, between 18 and 45. And Kansas has similar statutes that say the same thing. Now the National Guard, that is that part of the militia that has been organized. But everybody else is part of the unorganized militia. And you know, if you watch a meeting or two that we're all involved in, it looks pretty unorganized too from time to time. Mark's the exception. But to preserve liberty, Richard Henry Lee wrote, it is essential that the whole body of the people always possess arms and be taught alike, especially when young, how to use them. Such are a well-regulated militia composed of freeholders, citizens, and husbandmen, who take up arms to preserve their property as individuals and their rights as free men. Patrick Henry, I know him, give me liberty, give me death. Sometimes Mom told me, be careful what you wish for. He went on to write that the great object is that every man be armed, everyone who is able may have a gun. Guard with jealous attention the public liberties. Suspect everyone who approaches that jewel. Unfortunately, nothing will preserve it but downright force. Whenever you give up that force, you are inevitably ruined. At the Virginia Ratifying Convention, he said, "My great objection to this document is that it does not lead us or waging the war against tyrants." And that was the part of the big struggle between the Federalists and the Anti-Federalists. The Federalists said, we just need the Constitution. The Anti-Federalists said, we need just a little bit more. And so that part of that compromise was the 10 amendments that became the Bill of Rights. Trench Cox was a member of the Continental Congress, said, "Who are the militia? Are they not ourselves? Congress have no power to disarm the militia. Their swords and every other terrible implement of the soldier are the birthright of an American. The unlimited power of the sword is not in the hands of either the federal or state governments, but where I trust in God, it will ever remain in the hands of the people. The people are confirmed by the next article, the Second Amendment, in their right to keep and bear their private arms." And that was his introduction to the discussion on the Second Amendment. John Adams, president, vice president, they played musical chairs there for the first 50 years or so, as we ran our government. Continental Congress member, signed the Declaration of Independence, said that the arms in the hands of the citizens may be used at individual discretion in private defense. James Madison, another author, the Constitution, fourth president, Secretary of State, they're all like playing musical chairs, said Americans have the right and advantage of being armed, unlike the citizens of every other country whose governments are afraid to trust the people with arms. George Mason, I ask you, who are the militia? They consist now of the whole people, except for a few public officers. To disarm the people, that is what the best and most effectual way to enslave them. I consider and fear the natural propensity of rulers to oppress the people. I wish only to prevent them from doing evil. Noah Webster, he was actually in the Revolutionary Army before he wrote the dictionary, and said, before a standing army can rule, the people must be disarmed. As they are in almost every kingdom in Europe, the supreme power in America cannot enforce unjust laws by the sword because the whole body of the people are armed. A people can never be deprived of their liberty while they retain in their own hands a power sufficient to any other power in the state. Alexander Hamilton, Continental Congress, Revolutionary Army, Federalist Papers, Secretary of the Treasury, $10 bill, famous Broadway play, said that the best we can hope for concerning the people at large is that they be properly armed. Hey, any of them talking about duck hunting? No. Target shooting? No. Well, they would go out and train and drill, and they would do target shooting. Collecting? No. A lot of times when we look at public policy, it's often a balancing test between safety and liberty. And we all know what Benjamin Franklin said. Those who will trade a little safety for liberty deserve neither. So, it's really rights, individual rights versus the authority of the government. It really is about power. Now let's look at some of the terms. Probably the word that, the set of words that is the most perplexing to courts and to others in trying to interpret it is the term of art, the people. What is the people? Well, when we look at other usages of that same pair of words in the rest of the Bill of Rights, it says, we, the people of the United States, in order to form a more perfect union, that chosen every second year by the people of the several states. That's like when they elect congressmen. The right of the people to peaceably assemble in the Third Amendment. The right of the people to keep and bear arms, of course, in the Second. The right of the people to be secure in their persons and houses in the Fourth Amendment. The 10th Amendment. I got this silly little icon thingy there. That to disparage the other, no, reserve the power, the 10th Amendment. What is not expressly given to the federal government is reserved to the states, respectively, or the people. So it's pretty clear when you read the 10th Amendment that the states and the people aren't the same thing, despite what the Kansas Supreme Court said about 100 years ago. So, restrictions on constitutional rights, you know, I mean, even the First Amendment isn't a broad, uncontrolled right. You can't yell fire in a theater. You can't publish pornography. Well, you can now on the internet, but, you know, it's horrible, I know. But it could be criminally prosecuted. There are administrative rules that affect it. For example, if someone is declared by a court in a due process hearing to be a danger to themselves or others, they are disbarred from being able to possess firearms lawfully. They have a due process hearing. They have an opportunity to be heard. The judge makes a decision. You know, if they have a criminal conviction, a felony, they can't have their rights restored. And how rights are restored varies from state to state. The states actually control that, just like they control the methods of voting. There are certain overarching federal principles. And if you're, for example, prosecuted for a violation of federal law, then there's a federal procedure called relief of disabilities, because you're part of a disabled class when you're convicted of a felony and can't possess firearms legally. Other rights that are restricted by law, of course, religion. You know, you can't go around sacrificing virgins. Assembly, you can't conspire together to commit a crime. And rights do have their downside as recognized by our founding fathers. In that quote, for example, they can have some costs, and that's why we have protections for assembly, against illegal search and seizure, against double jeopardy, against self-incrimination, right to a speedy trial, right to counsel, and that, for example, cruel and unusual punishment is prohibited by the Constitution. Some of the infringements that we have seen in the past that have been interpreted by the courts to be said infringements include like waiting periods, bans on entire classes of firearms, licensing or permitting. You know, I hear all too often the analogy to a car. Well, you know, driving a car, owning a car is a property right, and you can buy all the cars you want, whether you've got a license or not. You just can't drive them on the public street. You know, they can sit there and go round and round out there on the South 40, and go play with their, you know, if they've got a restricted or revoked license, they can't be prosecuted for that, but they can't drive that little dune buggy on the street and not get in trouble. And, of course, there's no right to own a car. There's no right to drive a car. Well, there's no right to drive that car on the street. That's what the regulation is. But it is clear that the right to own a firearm, unless you become part of that disabled class, is a right that is recognized by the Second Amendment. Now, we've had other kind of goofy laws. You know, we are so blessed in Kansas. People just don't understand it because they haven't seen what other people in other parts of the country have to deal with, like I have. There are some states that say you can only buy one gun a month. My wife would probably like me to have that rule, but you know, I come home with a box every once in a while. And she doesn't even ask what's in it anymore, thank goodness. For example, though, that some rights and the exercise of those rights can be offensive to others. I mean, you know, we've all got friends that just don't understand why we would want to own a gun or why we need one of them newfangled assault weapons, which is really assault weapons. It's just an emotional term, and it doesn't accurately describe the firearm. But think of some other things, for example, the downside of these rights. You know, you can't prosecute someone for burning the American flag or desecrating it. They do that in China, though. Well, not if you burn the American flag, just their own. And, you know, I know probably many of you don't agree with it, but the First Amendment can be regulated in the exercise of religion, that, they can't have public prayer in schools, but we all know what they do during a tough test. And then, Miranda rights, you can't be forced to confess. And there are instances where if the Fourth Amendment is violated by our government, that they don't get to use the evidence because of that violation, and some might think that's really bad. Before a Supreme Court case called Mapp versus Ohio, basically, if the cops kicked in your door and found whatever it was they wanted to prosecute you for, you could say, but they violated my Fourth Amendment rights, and the judge would just go, you can sue them in civil court. Oh, wait, you're going to prison, and the statute of limitations will run while you're there. So, the Supreme Court developed the exclusionary rule to try to punish bad behavior by law enforcement because they figured out that in Ohio, one search warrant had been issued in a decade. It was crazy because they didn't need them. They just went in, kicked in doors, did what they wanted. And so the exclusionary rule says, if you violate their rights, you don't get to use the evidence at trial. It's suppressed. And so, they started acting a little bit better after that, although they certainly aren't perfect. I mentioned kind of the assault weapons ban. Ladies and gentlemen, I've been watching this issue for a long time. And one of the things that I did, the reason I got that award from NRA in 1993 was I showed them how grassroots political organization worked in 92. When Eric Yost ran for Congress, we organized dozens of people. We made thousands of phone calls. We organized dozens of people to go deliver stuff door to door. And, we moved the meter. We didn't win, It's always about timing, too, in politics. Todd, of course, I worked with Todd in 94 to help him beat Dan. But they said, wow, that's really cool. You can move 5 points. You can move 6. And so they were kind enough to give me that award from the Firearms Civil Rights Legal Defense Fund. And then we sat down and wrote a book. And that book was used in about 250 congressional districts in the following cycle in 1994. And that was after the Brady Bill was passed in 93 and after the semi-auto firearms ban was passed in 1994 by one vote in Congress, one vote. And, we flipped Congress. And there's no doubt in my mind that people just like you that got out there and walked door to door and delivered flyers and made phone calls and talked to their neighbors made all the difference in the world. And after 1994, the President Clinton's pollster told him, you won't lose a seat in Congress if you pass the semi-auto ban, because he had polling that proved that. And he didn't see how things would change and how the grassroots could rise up and change this country and change the political landscape. And Bill Clinton was pretty depressed in 95. He had a lot of issues. He made a couple really big mistakes that year. And Monica. And, and then he kind of bounced back. But ever since then, Democrats have been gun shy, literally. They have not wanted to talk about the issue. And I have to tell you, this is the first time since then that I have seen the anti-gun forces in this country really ready for another fight. And I don't know about our side really being that well organized right now. We're in so much dissension because of the knife fight we've had in the Republican presidential primary, and there's so much bad feelings going on right now. The people I've talked to in Washington, D.C., and the articles I've read and the polling I've seen tell me that Republicans are in an awful lot of trouble. Not only are they talking about losing the Senate, but have anybody ever go to realclearpolitics.com? Absolutely fabulous website. Another really good one is Politico. But the great thing about RCP is that they are a great service in that they compile all these articles and all the polling done. And then they come up with averages of 10 or 15 polls. And so what that really does is give you a sample size, instead of 1,200 voters, 12,000. And then when you average all the polling done and look at the way it's moved over the weeks that it's been compiled, that some head-to-head races that we may end up with, it's pretty clear right now that while Indiana will probably decide the Republican side, I think it's obvious with the news today that Bernie has already decided, with laying off about 2/3 of his staff, that his game's over. So that means we're going to be looking at Hillary. And you know, Bernie, because he was from Vermont, really pro-gun state, you know, they had constitutional carry for 100 years before Kansas. They didn't have a prohibition against carrying concealed firearms. He made a couple good pro-gun votes, and he understood the demographics of a quasi-rural state like Vermont. And he knew that if he wanted to get reelected, he couldn't be quite as anti-gun as Hillary. And Hillary has beaten the tar out of him in the debates with that distinction in their voting, both in the Senate and activities that they've had when they were outside the legislature. What's kind of interesting is that Hillary is running very different commercials on the gun issue in the East Coast than she did in Iowa or in the Midwest, because she knows that there are a lot of Democrats that are pro-gun, and there are a lot of Americans that are pro-gun. And so some of the things that she has said, and you just have to like put in Hillary Clinton and gun control, and it comes up on the issues. Another really great website has all the candidates, and it compiles like news reports and quotes from them over the years. And it's really apparent that while we all know what the T-Hart Amendment is, it protected firearms. Well, one of the things that Todd always voted for was protecting firearms manufacturers from these civil lawsuits. Well, that's the first thing Hillary wants to do, is undo that federal statute, because they want to make General Motors responsible for every drunk driver. Oh, wait, no. They want to make every manufacturer of firearms responsible for every crime committed with their product. That's one way to destroy the Second Amendment. They don't want to shield manufacturers from lawsuits. They wanted, in 2000, she advocated for creation of a national firearms registry. Does this mean like it's a shepherd's crook?
No, almost.
Almost.
We do want to have time for quick Q&A.
Okay, sure. The balance of lawful gun ownership and keeping guns from the hands of criminals. Not much balance there for her. Of course, we all know what Bill Clinton's former chief of staff did in Virginia this week. He may not let them have guns, but he's going to let them all in the ballot box. The balance of lawful gun ownership and keeping guns from criminals. She wants to crack down on the assault weapons, go back to that, when in fact, you know, they're just not used in crime. Let me talk just a little bit about polling, because I know I'm running out of time. There's some great polling out there, and what is really amazing is that things have still been moving the pro-gun way since the 1990s. When we look at Americans' view of the National Rifle Association, 58% in just a few months ago were determined to have a favorable view of the NRA, as opposed to only 35% were unfavorable. That was actually reversed back in the early 1990s. And so Americans, I think, have figured out that, you know, it's, you know, you've got to have the means to protect yourself and your family, because it takes a few minutes for them to get there if you're lucky when you call 911. And also with the terrorist issues that occurred in San Bernardino, Americans realized that, yeah, them cops are great when they get there. All too often, frankly, all they do is get to clean up the mess. Sad but true. Gallup polling also was one. Another one was Rasmussen and ABC. Even after Sandy Hook, even after San Bernardino, a majority of Americans, 53%, oppose banning semi-automatic firearms. When back in 1994, 80% supported. So there's been a very positive trend, and I think that's obviously why, for example, Hillary Clinton has decided not to run anti-gun ads in jurisdictions that she knows aren't with her. She's smart enough to do that. So, I got so much more information, but let's go ahead and go to
I
questions.
think a lot of that will come up in questions. If you have a question, just raise your hand, and I'm going to try to get to everybody at least once. And so if you can kind of be concise with your question, don't try to make a statement. You know, everybody came here to listen to Phil, and you know, sometimes you have to build your question a little bit, but keep it to a minimum of time. So
I
you
help
can
the
hear.
lawyers do that too.
Okay, so
So,
anyway, if you don't mind, Phil, someone who wanted
Sure.
to be here tonight couldn't ask this question. She is a pro-life person. She has a felony in her history. She has recently remarried, and her husband is a gun enthusiast. Does that mean that they have to get rid of all the guns in that house? And who owns the firearm that is in their nightstand on her side of the bed? Who owns the firearm in the nightstand on his side of the bed? How does the state divide the bed?
Okay, when you look at the case law regarding possession of a firearm by a convicted felon, it's about the ability to exercise control over it. So it's not about who owns it. It's about who has control over it. So, for example, you're driving along in the car and it's underneath the seat. Well, you have control of the car. All right? What hubby should probably do is get a lockbox with code. And he be the only one with the code. If he has more than just a handgun, he should probably have the only key to the closet that they're kept in. So that there's no question about it. Because the last thing they want to be is a test case.
Right.
Yeah.
That's a good answer. Okay, let me see your hands. Anybody who has a question?
I'm really not supposed to give legal advice because now that I'm a referee, I can't be a coach. But I can explain what a hypothetical with criminal cases that I know have occurred.
I'll give legal advice that you put the gun in the bed between them. That way, he's got control.
Okay, do we have any questions? If not, I'm going to, oh, here we got one. Brian?
I'd like to see if perhaps I could at least, and if anyone else wanted them, perhaps a copy of those notes compiled with the quotes about the...
It's on a PowerPoint slide. You know, I can email the PowerPoint to
Could we put
Mark.
it on our website?
I would appreciate those.
Sure.
Could we put it
Sure.
on our website?
Oh, they're all quotes that are readily available.
Yeah.
I mean, you know, if you go to Citizens Committee, they've got a great little pamphlet. I probably plagiarized most of that.
Yeah, but it's
You know.
Yeah, I was going to say, you have it very nicely compiled.
No, I appreciate that. That's like from 20 years ago when I did that PowerPoint. Yeah. I had to like make it go into a newer version so I could get it to work on this Windows 10 computer. Yes, sir. Our flying member.
Question.
I've read the Constitution and the state constitution on the militia, and I'm a little confused about the transition concerning tyranny of government, when that takes place. I heard a great quote. It has to do with the remnant of believers and the militia. It says you don't know who they are, where they're at, what they're going to do. All you know is they'll find you at the right time.
You know, there's not an objective standard. You know, it's subjective. It's, and you know, it is a place where, you know, if you're a little too early, you're the test case, and if you're at the right time, you're part of the tipping point. So, you know, we all have to use judgment. It is difficult to respond other than with a vague answer to such a vague question.
Well, my next question, part of the question would be, is, well, part of it's the age thing too.
I mean, have you ever read the Declaration of Independence to the, you know, at least the first third of it? And they go through all of the crimes that they believe the Crown has committed.
Yes.
that generated their desire. I mean, when was the last time they put a soldier in your house? Drawn and quartered your neighbor. All of those things that happened under the tyranny of King George makes everything we've got going on today just like pale in comparison. So, I think it's a subjective judgment that people have to make for themselves, and I hope that I think the best thing to do is to learn the history and the context of it, and then try to bring it forward into today. And, we should really count the blessings where we're at right now.
Here, here.
Well, I'm concerned about our blessings, and I think most people would question that some of the things that are going on are very treasonous, and I really feel in a way that maybe it's time for an unarmed militia to form, to show up and just encourage people to do the right thing. And I don't know when that happens, but I'm really concerned that if we wait too long, and I believe that that a lot of the checks and balances in the government, if you look at the federal government, you might say that the judicial branch kind of runs checks and balances on both the legislature and but when you can't get people to comply with subpoenas and different things like that, and there's all this other stuff going on, it's I think it may not be a soldier in your house, but it's pretty bad what's going on.
I appreciate that, and I'm still trying to find the question. But, okay,
How does the militia get called up?
well, the government is, the governor,
Not the National Guard. A lot of people think the National Guard.
not the National Guard. The unorganized militia, you just go read the federal code and the state law. And, the governor issues a proclamation, we all go out and march around in the field.
Okay, then
So it's up to the governor. The governor is the commander-in-chief of the state. If you go to the public library and look at the statute books, it just happens to be the very first title on one of the books, and I think it's 4. They're like 4A, 4B, 4C. But if you look at the book and right on the rib of it, it'll have militia right on it. You just start reading the very first section there. I can't remember the number off the top of my head, but it's not a very long code. And there have been efforts in the state legislature to create a Kansas State Guard, similar to what they have in Texas, which is separate and independent of the National Guard. The National Guard has a dual chain of command. The governor can call them out, or the president can say, they're going to go where I tell them to. So there's a statute there, Senator Dennis Pyle wrote a bill 3 or 4 years ago about creating a Kansas State Guard. And he was trying to couch it in sort of the terms of like an auxiliary or something like that, where, if there's a tornado or an earthquake, they could go stand and direct traffic. I don't know.
I yield my time to
Yeah.
the other persons on the floor.
Okay, thank you.
All right. Any more questions? Go ahead. Cindy?
Okay. There have been issues, particularly in the Veterans Administration, where if a veteran had had someone designated as their financial overseer, the VA check would go to the helper, that they were trying to disbar them from the possession of arms by that. And the problem with that was there's no due process hearing. It may just be that the guy's going like, I don't want to mess with it. I got enough issues with my medical condition or whatever. And I trust my brother. He can take care of it for me. And they were trying to use that as a means. But it's really clear under federal law that you have to go through a due process hearing like we have in our probate court here. And it's, trying to remember the case designation. But it's like a finding by the judge that you're a danger to yourself or others, or they can commit you to Osawatomie, but of course there's no room at Osawatomie, so we don't know where to put them right now. But they're all full up there in Larned. So the legislature's got their own problems there.
Let's see, I'm on this committee,
Well, it wasn't a law. It wasn't a law. It wasn't a statute. It was like trying to do it with an administrative regulation. And that doesn't have the same force of law, and it was basically focused in the VA. So, I don't think you've got anything to worry about there. Simply because you have a medical condition, that doesn't make you a danger to yourself or others. I know that it may restrict you from being able to operate a vehicle, but that doesn't apply, to a firearm.
Anybody else? If nobody else, we got one back here, go ahead.
Concealed carry, if someone does not intend to get a concealed carry permit, what value is there in taking a concealed carry class?
Well, I think, okay, now this is the firearms instructor in me coming out. And I'm a handgun instructor for NRA, and now Derek, my son, and I are instructors in 4-H, and Derek helps with BB gun and air rifle, and he's shooting air rifle with 4-H right now. We've got a great program here in Sedgwick County. And the truth is, handgun's a pretty tough thing to hit with consistently and accurately. And the problem with it is such a short sight radius that you end up with, you look at the geometry of it, that your margin of error becomes minute compared to a long gun. Which just, you just draw it out on paper and you can see that with a long gun and your sights are 2 foot, 3 foot apart, your margin of error becomes huge, because if you just get them out of alignment just a little bit, you may be 2 inches off from where you want to hit. With a handgun, you're 2 or 3 feet off because of the difference in that geometry. And I think if you're going to get a handgun and you don't have a lot of experience, I think it's a great idea to go take a safety course. And they're offered all around town. There are NRI certified instructors like me that can teach basic handgun. I think it's important that if you do choose to exercise this right, that you do it safely and competently. And well, there's certainly no mandate that you go to the class. I think it's the smart thing to do. Now, the difference is, of course, a few years ago we passed what was called constitutional carry, which was essentially a repeal of the prohibition against carrying a concealed firearm on your person. But if you want to do that in another state, you ought to go take the class and get a permit, because 36 states, last time I checked the Attorney General's website, recognize Kansas permits and allow you to carry in their states too. So that's why you go through the class and take the test and pay the money and get the little card so you can go to Tennessee and carry, or Florida or Utah or, a majority of the states. So, there are some states like New York that don't recognize our permits, or Illinois that don't recognize our permits. But the vast majority of states do. So I think there's a big plus in having that. When it comes to handguns, though, and you're just getting started, don't go for the fancy Glock or any of that, because, you don't want to have to think about it. I'd suggest a revolver be your first handgun, because you don't have a safety to worry about, and you don't have to worry about having a round in the chamber, and, you just go squeeze, 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 son of a bitch, But anyway.
Go ahead, Art.
One last question.
Sure.
Which states are most adversarial to the Second Amendment?
I mean, those are obvious. You're not in flyover country. They're not very good. Up and down the East Coast, Maryland, New York, Washington, D.C., till you get to Virginia. Virginia's not too bad. But every state has its own quirky little laws, and it's a really good idea. There are a couple of really nice authors that do good work and compile all the different states' laws. Alan Corwin is one that I know, and he's written a great book. He just Korwin, and he's got his own publishing company, and and he's always working on the book, updating it. The ATF puts out a pamphlet that's really not intended for the general public, but for federally licensed dealers that looks at it. But you got to figure there's 20,000 jurisdictions, writing these laws and ordinances in the various states. And so, it's a constant struggle to try to keep it up to date. And the truth is, no matter how good they are, no matter how hard they work, they are always going to be behind the curve. So, if you're going to go to a state, go to their website. The Kansas legislature has a great website. You can search Kansas law. And, well, I can quote you, it's like Chapter 21, or Title 21, Chapter 42. You can read that little section about Kansas firearms laws. If you're going to go to another state, it's probably a good idea to figure it out and not roll the dice.
I would like to give, well, go ahead.
They will still have a right to a speedy trial.
Oh, absolutely. We cut them loose once in a while when we drop the ball in the courts, regardless of what they're charged with. The right to a speedy trial is governed by both federal edict, like through the Constitution, and then there's a state statute that defines it. It depends on whether they're in custody or not. If they're in custody, it's a much shorter window than if they're out of custody. I think it's 90 and 180 days from the time they're arraigned, when they're, that's usually after a preliminary hearing. Then they're arraigned formally on the charges because there's been an actual finding of probable cause that they committed the crime. So it runs from arraignment to trial. But if their lawyer's going like, I need a little more time to get ready, they don't count that time. If the defendant goes, I'd really like to think about that plea bargain, I'd like a couple of weeks to do that, they don't count that time. So it's usually only the time requested by the state, like if they can't find a witness or something like that, that goes against the speedy trial time. It's an incredibly complicated computation, and usually the judge has to get the lawyers to shut up and just do it for them. But,
We had a relative who was accused by his ex-wife, and he was innocent. And he was in jail for almost 9 months.
well,
And when he
and
was brought to the judge, the
Yeah.
judge dismissed it because there wasn't evidence. He had not done what
Yeah.
his wife accused him of. But he has been lined on cement.
well, you have to go in and look at who asked for it to be continued, because I'd be willing to bet that most of that was his lawyer. Yeah, because it's 6 months or not 3 months is basically. But see, and you can get charged with a crime, and then they can drag out the preliminary hearing for 2 or 3 months before they have that, or they waive it. So that could have been a big chunk of it. And then once they have a preliminary hearing, then they're arraigned on the charge, and then the 90-day clock starts. So you could have 2 months before arraignment, 3 months after. That's 5 out of the 9 right there. A couple months for the prosecutor, a couple months for his lawyer. We're at 9 months. Yes, sir. You had a question?
My question is just been off about your questions.
Sure.
If we are discharging a firearm, long or short, are we not legally held responsible for the placement of that bullet? So if it hits somebody?
Well, absolutely right. And Kansas law is different. Kansas Supreme Court opinions have determined that it's strict liability if you discharge a firearm and you hit somebody you don't mean to. That doesn't matter. You're still responsible. And there was a case where essentially the stepson took the firearm that was not locked up and took it to a party and showed all his little buddies, and there was an accidental discharge and it shot the little girl in the leg. It was at the party, and the parents of the little girl sued the boy's parents and won because they had negligently stored the firearm.
And that's what.
And it's strict liability. And they're trying to. Some have tried to change that in the legislature, but they haven't been successful yet.
Which is the reason I would be driven to showing proficiency in being able to discharge a firearm, being a short or long, and being a responsible.
Well, hopefully so you avoid those consequences.
Exactly.
If you're able to hit someone, but you intend to. Yeah. Okay.
I've got one last question I would like on tape, if possible.
Sure.
Let's say that you have a person who's graduating from college. They're in a family that is not familiar with guns, and they want to, they're considering a concealed carry permit, or they want to carry a permit because the area they're living in is not the best part of Wichita. What advice would you give someone who's really starting with a blank sheet of paper? In other words,
Well, if they want-
what's
okay.
the forest rather than the trees?
Okay.
Just
For
what's
around the
overall?
house, I would assume that their home is their real
Well,
concern. It's not
apartment.
when they're away at work or when they're at the mall shopping. It's when they're at home.
Right.
And my personal preference would be to recommend a shotgun and a 20 gauge, so it doesn't kick as much. You know, like a Mossberg 500 or Remington 870, something in the $250 range. And the great thing about a shotgun with small shot is that it won't go through the drywall and kill your neighbor in the next house over. You know, because you look at the house construction. You look at house construction. You know, you've got a 1/2 inch of drywall and a 1/2 inch of particle board and a little vinyl siding. 9mm will go through 2 or 3 of those walls before it slows down, unless you get lucky and you hit a stud. But with a shotgun, with like number 8 or 7.5 shot in it, you know, each individual pellet is so small that it'll pretty much disperse all of its energy. And you won't go through into your neighbor's house. You might make a big hole in the wall, but, you know, that's all you're going to end up with. And I think a shotgun one also offers the advantage of being able to point it more accurately. You end up not fighting that short sight radius problem for your margin of error because you've got a long sight. And, you know, like from here to the door, it's not going to open up at that much. So it's not like what you see on TV where they go bang and you just see holes in the wall going all the way down. You know, it's only going to open up about that much.
Okay, they put
and
the gun
20
in the car.
gauge is well, you know.
And they cover it with a book bag. Is that a concealed weapon then?
Well, you know, there's no violation in transporting a firearm now in the car.
In Kansas,
In
all over in
Kansas.
every city?
Yeah, we've gotten rid of all the city ordinances. That was one of the other bills that I passed
Okay, that's good for
before
people
we
to know.
got right to carry. We dealt with Elmer Broadfoot's legacy, and we repealed with what was called a statutory preemption, where the Kansas legislature said, you know, we think it's in the public interest to have one set of rules from border to border, and we're going to get rid of all these inconsistent city ordinances. Because in counties like Johnson County, if you drove down I-35, you went through 7 different jurisdictions with 7 different sets of rules, and, you know, with 7 different sets of definitions. And so it was impossible to...
But all bets are off as soon as he crosses the state line.
Well, yeah, he's in a different jurisdiction. So you got to look at Missouri's law, or Oklahoma's, or Nebraska's, or Colorado, or Arkansas.
Okay.
Yeah.
Good answer.
So, you know, I think that handguns offer special problems in the practical application of them and the proficient use. And, you know, when I talk to someone, I say, look, you know, one, if it's like an auto, if it's a semi-automatic handgun, you got to break it in just like a car engine. You need to go run 300 or 400 rounds through it, especially if it's a brand new gun, you know, and make sure it works properly. Revolvers, you don't have that issue with. And, you know, I think it's a big mistake. Everybody wants something really easy to conceal. And the fact is, you know, you get a little 2-inch snubby and it's got some sight milled in the back strap, you know.
Yeah.
You know.
Go anywhere.
And it just can't, you know, they just aren't that good. Once in a while, you know, unless it's a Colt. I love Colts. But, you know, some of the products out there aren't very good. And, you know, I really don't like these little flat autos they've got out there, like a Ruger LCR or LCP. You know, you just can't hang on to the damn thing. You know, because you just got the front and the back of the grip, and your hand isn't even touching the sides, and you shoot that thing, it's hard to not drop it. You know, and especially if it's like 380 or bigger. You know, I'd like Berettas a lot better. Yes, sir.
I have a handgun that shoots shotgun ship.
Oh, a judge. Yeah, I got a judge. Yeah, judge has to have a judge, you know. Yeah, it shoots 45 long Colt and 410. You have to be really careful with that. Because
My brother-in-law says that out in California, they could be classified as a sawed-off shot.
I wouldn't doubt that. That goes back to the definitions. And you got to be really careful with that because you can't shoot normal out of the box for your long gun 410s in it. They're a little too hot for it. And there are manufacturers that produce rounds specifically designed for that short barrel. And they've come apart. They've had them stretched. They've had the top strap stretched when they used ammunition in them that was too hot. like for a normal, like a break open shotgun or something. And you can get 410 that, that you get ammo that's designed specifically for that gun, because it's really not intended to shoot the full power stuff. But yeah, it's like 338 slugs popping out with one pull of the trigger.
Okay. All right, well,
Awesome.
we have used up our allotted time.
And y'all missed a good gun show last weekend. Oh my goodness, there was nobody there. You know, all the gun dealers were going, oh my God, what am I going to do? You know, we didn't have any sales. I said, don't worry, it'll be a lot better after November.
Let's give Phil a big round of applause.
Thank you so much.